Right, everybody. I know people will join us as they are making their way back home. Welcome on a Tuesday after a long, what feels like the longest SCOTUS season of my life. I welcome all of you to our SCOTUS chat, Mahmoud v. Taylor. Today, we're going to talk about children books. I mean, I don't think a SCOTUS decision has ever cited so many adorable slash sweet and child-centered literature, but here we are. And um, here with me today for our SCOTUS Brief, I welcome Rebecca Marquardt, Vice President and Legal Director of Americans United for Separation in Church and State. Welcome, Rebecca. Thank you for being here with us. And I also welcome David Aaron. He, him pronouns. He's the General Counsel of Education Minnesota. And Rebecca, I'm so sorry, you use she, her pronouns. And I'm your moderator, Iman Hassan. I use she, her pronouns. I'm the Gender Justice Advocacy Director. And before that, spent most of my time advocating on behalf of parents as an education and disability attorney. So, probably the first time ever in my life that I wasn't rooting for parents, strangely enough. That's what the Supreme Court has done to legal advocates in the education sector. Just to give you an overview of our hour together, we will be discussing the case, the impact the case has in our jurisdiction in Minnesota, and then also leave some time for Q&A and ways to get involved. As you see, there is a Q&A section. Please feel free to ask questions throughout the chat, but we will make sure that at the end we address questions and allow you to pose additional questions that you weren't able to throughout the chat. So with that said, I want to jump right into, let me put these books down. I'm going to jump right into the case because there's a lot to digest and there's a lot to talk about. As I said, this case is about children books, but not so much about banning them, but what it means for school districts to have the presence of books that have LGBTQ plus themes and show a window into the lives of family structures that we're all exposed to in the real life. But what happens when parents do not want their children to be exposed to the reality of an inclusive world? Well, parents asked exactly that question, and they demanded that their school district gave them the option of being notified and to opt out of curriculum that burdened them and their rights to free exercise of religion. And yet last week on Friday, the Supreme Court sided with those parents. The court concluded that the board's introduction of LGBTQ plus inclusive storybooks combined with its no opt-out policy burdened the parents' right to free exercise of religion. The court found in favor of the parents and said they are entitled to a preliminary injunction. So they overruled the lower court. Here with me today, two brilliant minds that know a lot about this. And I want to first ask to both of you, after finding the results and hearing the oral arguments in the spring, are we surprised? Maybe not about the 6-3. What are your first reactions? And I'll give it to Rebecca first.
Thank you. Thank you so much for having me. I'm really excited to be here with you all tonight. I was not surprised at all, especially after the oral arguments, but even when the case was granted for review, we knew that the outcome would be bad. This is a court that has been captured by Christian nationalists who are, for lack of a better term, hell-bent on imposing their very narrow religious views on everyone in public life, but more specifically on public school children. And so it was not surprised at all that it came down 6-3. The oral arguments for sure bore that out. And I'm not even surprised really that it was an opinion that was drafted by Justice Alito. I think he was sort of salivating for this type of opinion to write on it. And probably was thinking about how he would frame it from the moment that it even went up to the Fourth Circuit. So I don't think it was a surprise at all. It's unfortunate that it wasn't a surprise. And there were some other cases this term that we were like, oh, it wasn't as bad as we thought. But this was unfortunately not one of them.
What about you, David?
Yeah, I agree with Rebecca. I think this outcome may have been a surprise if it had been decided by the Supreme Court 15 or 20 years ago. But this current majority, and now that it's the 6-3 supermajority, has really been on this trend of, looking at the First Amendment and really elevating the free exercise clause over the establishment clause, and really minimizing, anything that could potentially be an establishment clause violation. I think we saw that in two school cases in 2023. Kennedy versus Bremerton was a case where the court found that a football coach employed by a public school district has a First Amendment right to pray with students during a football game or shortly before it. Something that would have been really shocking to the court, I think, a generation before that. And I think they similarly said that schools have the state of Maine has an obligation if they provide vouchers for private schools, they have to allow them for private religious schools. Also, a huge departure from past First Amendment jurisprudence. So I think that this is just the way that the court is heading. They're incredibly protective of what they view as religious liberty, but really to the detriment of anyone else's rights in a school.
And I know the parents, both in their arguments and through their counsel, are saying we're not asking for a book ban. We're just asking for ability to be notified and opt out of curriculum that harms, just by mere exposure, our children's religious upbringing. What trends will we see from this decision? Because yes, people are minimizing it, but as you both of you said, this is really a departure from some case law. What do we think on the ground will happen with this decision? What trends will we see?
I think it's always hard to predict, exactly how far, subsequent plaintiffs will take this, but I think this case is not happening in a vacuum. This is happening at a time when we see a lot of, school-based equity efforts in support of LGBTQ plus students under attack by the Trump administration, by the U.S. Department of Education. And this, I think, just adds to that, this idea that just being around LGBTQ plus people, I mean, here it's characters in a book, but I think it doesn't take a huge stretch to say that, any organic discussion in a class that comes up related to LGBTQ plus people is going to give rise to some First Amendment right by parents to remove their children from that conversation. And I think that that's pretty troubling, in light of the fact that our society is more diverse and pluralistic than ever. And, kids are going to encounter other kids who are LGBTQ plus, who have same-sex parents. And I think it's, these books that this school district used, more children's book pages, I think, than have ever been in a Supreme Court decision. But they're tools for educators to help kids fill in those gaps. And I don't think that they, contrary to what the majority thinks, I don't think that those books were telling kids that their religion or religious beliefs were wrong, but that everyone is entitled to some dignity and respect. So I think the trend is really, or my fear, and I hope this doesn't come to fruition, is that even though it's not an outright book ban, that there will be a chilling effect on the ability or the willingness of school districts to include these books in the curriculum, just because of now the burden of having to, what Justice Alito says, is notify parents and then, allow them to opt out. That's an incredibly difficult thing when they're books that are used intermittently throughout the curriculum. So they weren't asking for a book ban, but I think that may be the result in some cases where school administrators or educators decide, you know what, in this community, it's just not worth the hassle. And I think that that does all students a disservice.
I agree. I think that it's going to be difficult to map out exactly where the the trends are going to take us, but I think particularly when we're looking at religious liberty cases, I think we kind of know where this court would go and where our adversaries. There is a huge billion-dollar shadow network of Christian right legal organizations that have been teeing up different types of cases, waiting for a federal bench that was going to be very friendly to these positions that they're taking, sometimes very extreme positions that they are taking. And that was all laid out in Project 2025, right? And so I think when I look specifically at this case, one of the concerns I have is that um, forcing a school district to have an opt-out system that is unworkable, and they've already said it's just not possible for us to do, is going to increase the opt-outs in other like areas of teaching if there's disagreement with religious beliefs and whatever issue or topic of curricula that the parents have. And so one of the obvious things that comes to mind for an organization like ours is the teaching of evolution, which there are a lot of religionists who believe that evolution is just a theory and not a scientific fact. And they would rather that it not be taught in schools. And if opt-outs are allowed, this is something that could happen where suddenly children are not being taught evolution because there are so many opt-outs that it's just impossible to conduct school. And um, I think that that goes also for, religions who don't believe that women should work outside the home. I think this is something that Justice Sotomayor brought up a lot in the oral argument and in her dissent. This focus on what could come next. And I have a quote here from her that says, "Next to go could be the teaching on evolution, the work of female scientists Marie Curie, or the history of vaccines." And I do think that those are very real threats. And I know for sure that there are organizations that are looking at how can we use this now to undermine the teaching of evolution in our public schools. And I think it's dangerous that you have a certain subset of parents that really are micromanaging the curriculum of public schools. And like you and David have both said, it wasn't an outright ban on books, but it really was an underhanded one. I mean, the real practical impact of this decision is that Montgomery County is going to just pull those books from the shelves and not teach them at all. And that is the hope for some of these other teaching moments as well. Like let's just figure out a way to not teach, um, you know, evidence-based science courses and things like that. So I think those are some trends that we're going to see. And there is a movement in this country also to inject Bible study into public school curriculum. We have the Blue Bonnet curriculum in the state of Texas. Oklahoma wants to have more Bible infused curriculum in its social studies programs. And the interesting thing about that is I'm not sure how the opt-out system would work for those types of classes where they are bringing up the Bible or using the Bible as a textbook in public schools. I have a feeling that this opt-out system would not be available for those particular courses. But I think also the biggest impact that David also alluded to and sort of is underlying this entire webinar is just that this is just going to lead to the further stigmatization of queer children in public schools, and really showing that they are not represented in their schools. Americans United has a youth organizing fellowship, and one of our fellows had written a wonderful blog about the impact of the of this decision on him as a queer student. And I'm just trying to find the quote exactly so that I could read it to you, but I'm not finding it. But basically, he just talked about how as a public school student, he never saw himself represented in any of the books that were on the shelves in schools. And that the first time that he heard somebody call him gay, and that was an obvious insult, but he didn't quite understand why. And then when he looked it up, he didn't understand why those feelings were inappropriate to be having and things like that. And I really just think that it, you know, as we probably all understand and agree, representation matters, and they're not going to be represented there. And it's just going to increase their feeling of otherness, feeling of stigma, and bullying, really, even by adults in their lives.
Yeah, I mean, as someone who has done education advocacy specifically undoing hostile learning environments, I do wonder what this wave will look like. Even though it's not little kids reading this decision, the environment changes based on jurisprudence, which changes larger discourse around what we accept, right? And using your religion, your faith as a shield to participate in homophobia is unfortunately part and parcel of this decision, right? Lara said in the comments that as a refuge from a red state, they're already pushing that having an LGBTQ plus teachers or administration was a violation of their First Amendment right under the same rationale. And I just am bringing this in because it's in during the oral hearings. Sotomayor had these questions, right? Like, if a staff member has a picture of their spouse that is same sex, is that exposure, the mere exposure of the reality of family structures to a young child, also then within this rationale? And so I don't think we quite know how far this decision will go, especially with the really wide reading of Yoda. And so, like, I do want to bring this up, not to go deep into constitution law, but it's to me, it was really startling. The fact that the court stated that, you know, they basically said the books therefore present the same kind of objective danger to the free exercise of religions that they identified in Yoda, a 1972 case. And for me, that's very intense to like. I agreed with the lower courts. I was like, no, Yoda does not apply. Stop it. Because it's Yoda is really an affirmative coercion, right? A state compulsory mandate to keep your Amish children in school. This is very different. Your participation in public education is not in question. You want your children in public education, especially children who have IEPs, right? This is an intersection of disability. Some parents said, we can't take our children out because it's too expensive to have an education that also has to provide special education, right? So we want public education, but we want opt-out. And they said that is equivalent. The harm is equivalent to Amish families who could not educate their children in the ways that Amish folks needed. What do you guys think about that? I just need a moment to like digest this.
I can start. I mean, I think it's extremely disingenuous. I think that it is an apples to oranges comparison. In Yoder, the very act of attending school beyond 8th grade, I believe was a violation of the religious tenets of the Amish plaintiffs in that case. And there are other cases where the court has ruled for parents on First Amendment grounds. Saluting a flag in the case of Jehovah's Witnesses, as it was found to be a First Amendment violation. Here, there is no requirement by the Montgomery County Public Schools that students do anything other than hear these children's books that happen to have LGBTQ plus characters. So equating that with coercion, I just think is so dishonest and ignores those similarities. And I think it's done on purpose because they wanted to apply strict scrutiny to this case. And the only way to do that would really to be kind of Yoder had historically been understood to be the exception to the kind of more general rule in a case called Employment Division versus Smith, that generally applicable laws that are neutral to religion are permissible, even if there are small burdens on religion. That case was about, employment regulations and drug use, or the use, a person who was disqualified from unemployment because of use of peyote. I think that there are way more cases kind of affirming that precedent. This is a trend for this majority of basically pretending that they're not overruling a precedent while still, dramatically departing from it. They kind of did the same thing in those 2023 cases with the lemon test. They kind of said, lemon doesn't really matter anymore. It's been, it's basically irrelevant. But the court had never overruled the lemon test, which is like the test of whether there's an establishment of religion. So I think that's just the kind of intellectual dishonesty, frankly, that we have seen from the majority of this court to get to the outcome that they want for plaintiffs that they like.
I 100% agree with everything David just said. I will just add that I think my first reaction when I saw how they were characterizing Yoder in this opinion was just like, this is perverse. One of the quotes from the Yoder decision that advocates for true religious liberty and church-state separation use continually is that parents do have the right to direct the religious upbringing of their children. And I completely agree with that. But the way that this court and Justice Alito in particular used it, I think was dishonest and disingenuous and used in order to get a specific outcome here. And I think it's really important because, I mean, that decision is also typically cited in cases that are upholding the Establishment Clause, something that Justice Alito for sure does not respect or even want in our country. So it definitely was a very perverse reading of Yoder. And I also just wanted to highlight the fact that in the opinion, they said that it was the same type of burden as in Yoder. The cases were equivalent. But in oral argument, they were suggesting and outright saying that the exposure to these books through the ELA curriculum in Montgomery County was worse than what was happening to the Amish in Wisconsin, which is just mind-boggling. I mean, those kids were being forced to go to school in defiance of their religion. And this was just, let's remember, it's not that these books are necessarily being used as a unit to talk about like, hey, for this next reading unit, we're going to be talking about Pride Puppy. that might be what the court is going to do, or the school is going to do. But this also pulls them from the shelves for just the children choosing what books they want to read during silent reading time or read alouds. This is preventing students from saying, hey, during free choice, I'm going to read this book, and then the group of kids come around and also want to read it. So there's nothing necessarily affirmative happening in this situation, where it was very much so happening in the Wisconsin case. And I think that's something that has also gotten lost in the rhetoric of this, is that really these were just age-appropriate books that were going to be available for use in the classroom, whatever way that might be. It could just be read aloud. It could be just for children, like, having a diverse array of books on the shelves so that it encourages reading and, obviously the representation side of things as well. And then I will just say that I think I actually, never mind. We can move on.
I just want to add one last thing about this, and that just say that I think this decision, the majority decision, is also pretty insulting to a lot of religious people, because and I know that some of the plaintiffs argued this, but it just kind of accepts at face value the idea that religious opposition to, for example, same-sex marriage is the exact same thing as, like, people who hold that religious belief for themselves and their own family, that also means that those people oppose treating LGBTQ people with decency and respect, which is the value. And I just think that premise is profoundly insulting, even to people who have religious opposition to homosexuality or aspects of transgender ideology, if you want to call it that those things are not, naturally flowing from one another, but the court presumes that they are, that, any message of inclusivity towards LGBTQ plus people, well, that has to offend people of faith. And that's not true.
Not just offend, but also interfere with the religious upbringing of their children. That is a leap. It's a jump, maybe for this small group of families, but also picking and choosing what interferes with the religious upbringing and just choosing LGBTQ plus affirmative images in literature is not a very genuine way of interacting with public education, right? Like, I grew up as a Muslim child in Minnesota public education, and every time we talked about interest rates, that also doesn't align with the faith, but we understand that you bring up your children in a society that does not always align with your faith 100%. And so I think picking and choosing when you decide it's such an interference that you can practice your faith without the burden of losing public education, that's a stretch. And I think that's where the politicization of this topic is coming up, and it's really unfortunate. But here we are. And I mean, that kind of brings us into the next question. And I think Sotomayor goes deep into it, both in her dissent, but also in the oral hearings, with the questions of, like, what is the difference between exposure and coercion, and how are they making sense of it? Because Alito's, even the way that he talks about substantial burden or just burden, it's kind of all over the place. It's not the cleanest majority decision that I've read, but probably because they have to do so much circumventing of, like, established law and logic in order to make this happen. What do you guys think about the coercion versus exposure?
Well, I think the way that the majority treated it here is a radical diversion from decades of case law. We have always known that mere exposure to something that you may disagree with or may go contrary to your religious beliefs has never been considered a cognizable burden. And this is saying, well, no, exposure is a burden. And I think that is a radical departure from our current case law, and something that is very concerning. I also think that it is important for us to remember where we were procedurally on this case. This case went up to the Supreme Court on a preliminary injunction. So we have no record of what the burden actually is going to, or it actually is, because we don't know how these books were taught in schools, and what the exposure even was to the children. And I think that that is also an incredibly dangerous thing, that the court just sort of imputed its own version of what was happening in these schools to come up with this outcome.
Yeah, I agree with all that. I think the metaphor that I'll use, like, it's really just transforming, I think, the common understanding of the free exercise clause when it comes to parental rights in education as, not just like a negative liberty that the government can compel you to do something, but it's like now this affirmative right to kind of wrap your child in like this bubble wrap. And anything that they're exposed to in a school that offends your interpretation of your faith, you can force the school to shield them from, and that's never been how the First Amendment has been interpreted. So I worry not just for schools, but I think just inclusivity and non-discrimination. I think that's just a bigger area where this court is heading in terms of, striking down any types of laws or government regulations that are intended to promote inclusivity, particularly with respect to the LGBTQ plus community. These policies and laws enacted by democratically elected officials, but at the behest of parents with a particular interpretation of their faith, the court striking those down and saying, we know better, or the religious liberty of this group of people is more important than any type of non-discrimination principle.
Oh, Rebecca, you muted. There you go.
Always happens to me. Yeah, and Justice Thomas alluded to that in his concurrence in this opinion too, where he basically said that diversity and equity and inclusion, that were not important justifications that or important interests rather, that justified the policy by Montgomery County School Board. In essence, he's just saying that the religious interests of the parents are greater than the equity and inclusion interests of the school board, which is core to public education. We have this common school system because we want kids from all walks of life to come together and learn common themes and learn how to live with each other and be respectful and gain those perspectives that they wouldn't necessarily get at home, or it's just part of living in this pluralistic society. But Justice Thomas would say, well, religion is greater than that. And that is another theme that we've seen from this court time and again, that religion has a heightened status over all other rights.
Correct, especially our bodily autonomy, and now public education that is supposed to prepare the future citizens of our community. And apparently, and I like David, I like that image of, can you really bubble wrap your children and keep them away from all of the identities that are very much real, as much as our president is trying to make it seem like trans people don't exist, or community members that we know and love do exist. It says something about our court saying we can bubble wrap them, or at least notify and allow parents to opt out of the reality that we choose to live in, and a beautiful reality, right? What does this, let's go into, I mean, Minnesota was cited. This is the one time I wish Minnesota wouldn't be cited in a Supreme Court decision, but Minnesota was cited as like, look, Minnesotans are doing this. They have opt-outs. David, how does this interact with our reality? I know we were doing opt-outs, but we also have safe and, we have we have the Minnesota Human Rights Act. We have Safe and Supportive School Act. We are a jurisdiction that is actually known to protect our children from discrimination based on gender and sexuality. So how does this interact?
Yeah, so I think that is, an initial reaction by many as this case was winding its way up, and a lot of us had a good sense of how it would come out. There is a recognition that Minnesota has had this right of parents in state law. And I looked it up. It was enacted in 1993, which coincidentally is the same year that the Minnesota Human Rights Act was passed in Minnesota. I think one of the first state laws to protect sexual orientation in the country. So in that may have been some trade-off or compromise when that law was enacted. And that law is only 5 sentences long. It's for those who want to look it up, it's section 120B.20. And you're right, Justice Alito did note that law along with Arizona and Pennsylvania. And I haven't looked into those laws to see what they provide. But Minnesota's does provide a right of parents to review instructional materials provided to minor children in advance and to arrange for alternative instruction if the parents object to the material. It's interesting that the law specifically states that schools are not required to provide that alternative instruction, and they're not required to pay for it. The parents have the onus of initiating it, but students can't be penalized. It's an odd law because students also can't be penalized for any opt-out. So depending on how broad they're exercising that right, it does put schools in a bit of a bind in terms of what to do in order to allow the student to be not part of instruction, but not have any academic penalty resulting from that. I mean, I guess that's easier in a grade school. But I think one notable difference is, this Justice Alito's opinion says not only do parents have the right to review and, exclude their children from the instruction, that the school board, he says that the district court should order the school board to notify parents, if any similar books are used. And that's not an explicit requirement of Minnesota's law. So I can see that, if that having the potential to be, to impose some new burdens on educators and schools. If the request from parents is notify me anytime there is any LGBTQ plus content or characters featured in a book, that's tough. It's easy when it's a particular lesson. And it was interesting, in this case, Montgomery County did still allow opt-outs for sex ed, like a discrete unit, where you could say, okay, we know we're going to be doing this at this time. They did allow opt-outs, but I think it can be really, really burdensome under existing law and now under this decision, if there are books kind of used on an intermittent basis. Hard to predict when they're going to be used, when those topics are going to come up. And I think that there's really a potential, even in Minnesota, for some greater judicial micromanagement of our schools. Or like I said before, schools just saying it's not worth the hassle. of teaching this unit, because there are going to be so many people opting out that we're just going to scrap it. I think there is a trade-off with opt-outs, because this has come up when certain standards have been added at the legislature. There were changes to Minnesota's sex education law recently to have a more comprehensive, scientific, updated sex ed standards. And some of the objections, were about religious liberty, and it was noted that Minnesota has this right. So in some ways, it is beneficial, because in theory, it allows the majority of the class or other students, whose parents want them to get that information from educators, to receive it. But I think, especially if there's a lesson that's related to LGBTQ plus identity, or, aspects of racism or systemic inequality, what message does it send to the kids in the classroom who are part of that group or community, when a third of the class, grabs their books and leaves the room during that lesson? So I think that is, we have the law. It's hard to predict exactly what's going to happen as a result of this decision. I definitely think that in Minnesota, if you are listening to this and you're a school leader or an administrator or even an educator, our law requires all districts to have a more detailed policy about the processes and procedures. And I think it's a good idea for all staff to get some solid training about how they're supposed to handle these requests from parents, and what are they required to do when a parent asks, to be notified anytime a particular concept is introduced in class.
Yeah, David, thank you so much for breaking that down. I think this is the first time ever where I thought about the administrative burden of a school district and wasn't like, yeah, you guys have to do it. And notifications, I was just telling Rebecca earlier, notifications are so hard to get, even when it comes to disability advocacy, anything from manifestation hearings to IEP notifications. And what parents are really asking is like individualized learning, when, especially for the younger folks, right? If you pull them out from like first to fourth grade, like what do you do with young children that have to be in a separate space? That's additional costs of having other staff, spaces, supervision. I mean, it's unworkable. And that's why I agree with you. That burden will trickle down to some logical conclusions of most likely school districts that don't have the resources to fight this, perhaps not integrating these amazing books that create an inclusive space. So I don't even want to think about it, but we do have some great laws on the books that require adults to protect students from the type of discrimination and harm.
Yeah, I think that's right. I mean, Minnesota does have a law that was passed about 12 years ago called the Safe and Supportive Schools Act, that requires all districts to have policies to protect students from protected classes against bullying and harassment at school. And, as part of that, a lot of districts implemented anti-bullying curricula that include some of the very concepts taught through these books about kind of respecting everyone, understanding and valuing people's differences. So I think, while the law doesn't necessarily require that type of curriculum, it does require districts to investigate and have accountability when there is bullying based on protected characteristics. So there is still protection in that area. I think the opting out kind of, having a third of your classmates fly out of the classroom when there's an LGBTQ plus theme, I'm sure it doesn't feel great as a student. But there is still a right to have your school take anti-LGBTQ plus or racist or sexist or any transphobic bullying seriously. This court decision doesn't change that, fortunately.
Thank you. I'm going to get into questions. The first question I said, David hinted at this. It feels like the beginning of a slippery slope here. How long before parents can opt out of entire chunks of curriculum? And really extending this out given current pattern and what ACB intimated in her opinion in Scrimeti, RE, trans kids in protected classes, how long before parents can opt out of classroom placements with teachers whose values don't align with theirs. I'm not usually someone that goes down that kind of road of what if, but I feel like this is all laying the groundwork for using religious grounds to eat away at all kinds of rights and protections that have been found fought hard for. That's a lot to put out there, but yeah, I absolutely, I mean, I am not the person to ring all the alarm bells. I'm always, as an advocate, very hopeful, but I think it is setting the groundwork for a really dangerous precedent of what religious liberty should feel and look like, and also a very strategic attack against public education. We just have to name that. And David also named it earlier. There has been attacks on the Federal Department of Education, the Office of Civil Rights, my friends at DOJ that were doing incredible work investigating bad actors in different school districts. Some of the best people in the advocacy space of creating safe and welcoming schools in public education all over the United States are being strategically attacked here. So I don't think this is even like a very big what if, it's a right now.
I think we talked a lot about this when we were talking about the trends that we're going to see now that the Mahmoud versus Taylor case has come down, when we were talking about, opting out of any sort of curriculum that it offends your own religious beliefs. And I think that Kaylee's 100% correct that we're probably not that far away from parents wanting to opt out of having children in a classroom where pronouns are respected. And Justice Sotomayor also brought that up in her dissenting opinion too, in addition to, if there are certain religionists who believe that women shouldn't be working outside of the home, and what if it is a female teacher? Maybe women teacher are, that's a gender role that this court can get behind. But I think that it is laying the groundwork, and I think that it's something that we're going to see tested as we move forward.
I don't have anything to add on that one.
Perfect. I think this is going to be an important one. How can school boards protect our districts? How can we at least hold the line? I think that's a very important question. David, do you want to speak on Minnesota and then we can speak broadly?
Yeah, I think, there are still a lot of ways that schools can support, honest teaching and the civil discourse and all those things that kids and families want. I mean, I think, the vast majority of families make the choice to send their kids to I mean, Alito is so deprecating toward and offensive towards public schools, and it like basically refers to them as like a giant dumping ground. But I think that people want their kids in public schools because they want the exposure to different ideas and views. And I think that, having school board members who share those values, who are committed to inclusive education, and, they will seek advice of counsel about how to comply with this decision and comply with opt-out requests. But, I think just like we've seen with some higher ed institutions that like almost overcorrected in response to some of the threats from the Trump administration, I think it's really important that school board members not overcorrect in response to this fear of lawsuits and litigation, and that, to the greatest extent possible, preserve all of these things that have been done to make schools more safe and welcoming places. I never, I grew up and I don't think I ever read a book in school that had an LGBTQ plus character, and I still turned out gay. So all that exposure to heterosexuality did not transform me. So I think it's really important for school boards and school districts to not overcorrect in response to this decision, and really just deal with the opt-out requests that come their way.
And that connects to Taslin's question as well, around no, oh, sorry. Oh yeah, Taslin's questions around Teslin, as someone who has studied book bans, they worry a lot about pre-compliance when it comes to administrations, and you said that so perfectly. And we worry about that at Gender Justice, even in trans equity, specifically about gender affirming care, right? Like an executive order, while it creates a lot of discourse around what rights people have, does not change the law. And so we do a lot of work on educating folks and key leaders in our state of pre-compliance is a way to harm the rights of Minnesotans. And so I absolutely agree. It's something that we have to constantly do as advocates or as community members, like even talking to your school district. I mean, as someone who has sued a lot of school districts for good reasons, always for good reasons, never for discriminatory reasons. um, the constituents, right? The parents, the children that go to the school districts have power to have these conversations and to warn about pre-compliance and to set the tone of what kind of school district they want when their kids walk into the school buildings.
That's what I was going to say, just more broadly. I think that we see a lot of coordinated efforts across this country to change curriculum and have certain things done in school boards. And it's kind of an easy thing for them to do because, you know, eyes aren't necessarily on what's happening at school boards as much as they are at the federal level about what's going on in Congress, which, you know, these are elected officials, school board members, and those elections typically have lower turnout than some of our bigger national elections. So I think it's really important in order to protect your districts and what's being taught there, I think you need to know who your school board members are. A lot of them run unopposed. And so, like, what are they doing at the school board meetings? What sort of positions are they taking? Do they need to have somebody run against them? Understanding who they are and what they're discussing is going to be really important in protecting our kids' education. And then I also just want to say, we have this tendency to get outraged and complain about the things that we don't like. But when you see an elected official, school board member or not, doing the right thing, you should definitely be supporting them in that, especially in these times that are really, really hard. And being a dissenter in this environment is scary. You need to be able to support the elected officials when they're doing the right thing and show up for them as well, because they need to have that support. We all need to really be leaning into each other during these fights.
And I really have to give a shout out to the Minnesota High School League. They have been tremendous leaders in pushing back against really ugly and dark narratives around trans children participating in sports and participating in the community that they're part of, right? And so it's exactly that, Rebecca. Give them a shout out when they're doing the courageous and right thing that might get a lot of backlash, all the way to Pam Bondi writing threatening letters, which our AG is working really hard to protect Minnesota students as well. So I know this feels really dark, but I do want to elevate all of the people that are not abdicating their responsibilities to children in the state of Minnesota and fighting really hard to continue creating safe environments, both emotionally and physically, for students that are part of a community that people are trying to erase through words and decisions. So, yeah, thank you for saying that, Rebecca, because the work is hard right now, and a little bit encouragement to keep going the right path does a lot. I want to get to a couple more questions, and I know I need to stop talking. I get so excited just nerding out with both of you. Oh, this is a really important one, Foster. Thank you. What organizations can can you volunteer with to protect trans rights and dignity in the state of Minnesota? Oh, we can send out a whole list. We work with really phenomenal orgs. Gender Justice does a lot of this work, but we work in coalitions with lots of amazing people. Out Front does amazing work. We can send out a list. There are other ways of getting involved as well. My coworker Grace has put in some amazing resources from AU. We're going to also put in a link for anyone who's interested in trans equity trainings. I think becoming a leader and talking about how to protect our trans students is the way to do it. If you want to get involved, if you want to subscribe, check us out. Gender Justice, we send out lots of emails around how to volunteer, how to participate in advocacy, both in education, employment, and all parts of our lives. So I love people who ask that question because I like the engagement when we are facing quite a lot during this time, both federally and statewide. And then Foster had another question. There are a lot of people who operate in bad faith and public discourse when talking about trans healthcare. Is there any value in engaging with these bad faith operators, and what alternatives are there in engaging them? This is a brilliant question, just as I was talking about trans equity trainings and how do we engage with people who do not want to recognize the harm that they're doing, but are participating in active harm? That's a lot to answer, but yeah.
I think that this is a question that a lot of us have been wrestling with in these times too, where, you know, the country seems so divided and we can have very polarized conversations. And I think the biggest piece of advice that I have, and this probably isn't directly responding to your question, Foster, but I think that it's really important to continue to have those conversations and to engage in some way. I mean, especially if they are espousing lies or incorrect or inaccurate facts. I think that needs to be corrected, and they need to know when, you know, they are reposting something that is clearly wrong and harmful to other people. I think it's really important. But I also think it's really important to engage them in a way that is respectful, because the moment that you say someone is a racist or a bigot, they're going to shut down and you're not going to get anywhere. And so I think you have to come at it from a let me understand your perspective, would you like to hear mine type of situation. And that's really hard in these times. And I find it, obviously, as a lawyer, also very difficult to do. But especially if you're engaging on social media or something like that, you also don't know who else is reading that comment or listening to that conversation that you're having. And even if you're not directly affecting the person that you're talking directly to, you might be influencing somebody who's listening in or reading those comments. So not a direct answer. I don't know if David has a more direct answer, but that's usually what I say when we're talking about having difficult conversations in these times.
Yeah, I think on all of this is just to try and be open. I imagine if you're coming to this talk, you are generally on the side of LGBTQ plus rights. But be open to the side that people who have concerns about their kids encountering LGBTQ plus content in schools are capable of evolving in their views. Because we have, like it or not, we have evolved quite a bit as a society in terms of our approaches to these things, just from when I was in school to the books that are available to my daughters now, and that even people of faith want most people's faith teaches them to recognize the dignity of every other human being. So continue having the conversations and telling the stories about how your own thought process has evolved, I think is a powerful way to move people, and that's what this is all about at the end of the day.
I couldn't think about a better way of ending this. Such a positive and empowering note of unity in a time where we are having a hard time discussing difficult topics in a respectful way that doesn't harm people. But David, you're right. We still have an obligation to protect people from the actual harm while being empathetic and centering the humanity of folks that might use very disparaging and troubling language. So I want to thank you, Rebecca. I want to thank you, David. What a fun Tuesday talking about legal jurisprudence with two attorneys on education law. I couldn't ask for a better Tuesday. I want to thank everyone who came. We'll be sending out more resources, and please feel free to email us at Gender Justice. I know I didn't get to all of the questions. I wish we would have an hour and a half, but that's a lot to ask on a Tuesday, so I'll take the hour. Please let us know if you have any questions. And I am so sorry. I know we have North Dakotan folks here as well. This was very Minnesota heavy, but I'll do a legal analysis specifically for North Dakota and send it out. I am truly sorry. I think I got stuck in my jurisdiction because I grew up here and practiced here for so long. But I appreciate all the North Dakota folks that joined us today as well. Have a beautiful night.